From London to Ghana, yeah. BWF in the house, let's go. Integrity, excellence, we rise together. We stand with you. We stand with you. BWF, when the path is tough, we'll pull you through. From Seven Sisters to Accra too. We stand with you. We stand with you. On the high road in London town, 2028 on a house we're found. And Christine the sound. Family, immigration, wills and probate, we're around. 30 years strong in the game. We're gonna law in our name. When life gets heavy, we lift the weight. Together we claim the fame. Oh, you want a dream? You need a team. BBUF by your side, shine like the stream. From Accra's Golden Dawn to London City Gleam.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Restoration of child's British nationality. We are pleased to announce the successful outcome of a complex nationality matter, culminating in the restoration of British citizenship to a child whose passport had previously been cancelled. Background. Our client, a mother residing in the United Kingdom, instructed us following the cancellation of her child's British passport. At the time of the child's birth, the mother did not hold lawful immigration status. However, the child's father is a British citizen. On this basis, a British passport application was made and successfully granted in 2025, recognizing the child's entitlement to British nationality. Subsequently, during the course of the mother's application for leave to remain, the Home Office referred the matter to HM Passport Office. Both parents attended an interview, which proceeded positively. They were later invited to undertake a voluntary DNA test, which they declined, as they were entitled to do. Following this, the child's British passport was cancelled. challenges. This case presented several significant legal and evidential challenges. The cancellation of an already issued British passport, raising questions of lawful entitlement and evidential sufficiency. The Home Office's reliance on the absence of DNA evidence despite its voluntary nature. The need to establish paternity and nationality under statutory provisions without additional biological testing. The broader immigration context involving the mother's status, which risked indirectly impacting the child's position. Our strategy. Upon instruction, we adopted a comprehensive and structured approach. Statutory framework. We relied extensively on the British Nationality Act 1981, particularly provisions governing the acquisition of citizenship by descent. Policy and guidance. We deployed a detailed analysis of relevant Home Office caseworking guidance on nationality, paternity, and evidential standards. Evidential submissions. We compiled and presented robust alternative evidence establishing paternity and the child's entitlement to citizenship. Legal representations. We challenged the proportionality and legality of the passport cancellation, emphasizing that refusal to undergo a voluntary DNA test cannot lawfully negate citizenship rights. Strategic engagement. We maintained consistent and structured engagement with the Home Office to ensure proper reconsideration of the decision. Outcome. In March 2026, following our representations, the Home Office formally restored the child's British nationality. The child's entitlement as a British citizen has been fully recognized. The mother's parent route application is now progressing, benefiting from the confirmed status of the child. This outcome reaffirms the principle that British nationality, once lawfully established, cannot be displaced without a proper legal basis. Nugget, key takeaway. A refusal to undertake a voluntary DNA test does not extinguish a child's entitlement to British citizenship. Where sufficient alternative evidence exists, the Home Office must assess nationality in line with statutory law and its own guidance. This case underscores the importance of expert legal intervention in nationality disputes and demonstrates that incorrect or premature decisions by authorities can be successfully challenged with the right strategy. Facing complex immigration issues? Contact BWF Solicitors today.
You in a video, no, you can't about customary marriage, a friend of proxy marriage, although say and yet proxy marriage. And to UK, send you name no, or worry what Ghana, and I would never cry or the Baha, ubit media application. Bimus a win to me, but ubit media. So, worry what Ghana, if you are worry a friend of customary marriage, be more friend of proxy marriage. What about UK? Ubit me use to be your application. And to the main Maui. My mouse said about a Home Office immigration for a refusal application. 2% of your application is successful. Now Home Office for approval application till they make it. First of all, so I want any customary marriage. I will case be a friend of Kuju, UK case 2016. I said Mrana, Krona or Warren, Mrana one to see Ghana Brass. Ghana Mrana said, Ghana Mrana said, so we are customary marriage. I will say we you be Gina Hua or Bayes Adam amount. It's usually alongside Mammy and our papa or Bussian 4 and now I will near Bussian 4 or now for 4. I was so mal to me. Into Bayes Anna, my advice is a statutory declaration every UK and our power of attorney. And now even a simple consent letter with no ID, our dear account say 1 hour to me, so Munjina on Yawa. So we are bar Berman and so Massa. Senabaya in Kunia Yenina Amma Satumi. Omagina or Nabusian for no best swear statutory declaration. Now, what they call KMA, AMA, Metropolitan Assembly, District Assembly, baby, registry, marriage registry will be a the qua register and a more certificate be a friend of shadow 1. Year, once on the statutory declaration account. My registry and some bonnet and count. Letter na the Abaya and say, Adia or my Jenny, and our reading so much Ghana. If you want, Ebeco Foreign Affairs on the bonnet charges, Ebeco Court on the bonnet charges. Why you win in a bar and yet shed Sefako Ghana High Commission? But we beat me a Fako almost on bonnet charges. Name bomb wayɛ wei nyinaa wie no mesrɛw ɛwɔ sɛ wode ma Ghana ni anaa lawyer a ɔte Ghana mmara no ase a ɔwɔ nimdeɛ fa Ghana awareɛ ho ɔsɛ the lawyers no ɛnyɛ ɔmo nyinaa na ɔmote Ghana mmara ase a ɔwɔ nimdeɛ fa Ghana awareɛ ho ɔyɛ awareɛ no ɛyɛ soronko ɛnyɛ wiase nyinaa na ɛwɔ saa awareɛ no nti ɔsɛ yɛ Ghana ni a ɔte ase lawyer deɛ ɔbɛyɛ first of all ɔgye wano asɛm bi a ɔno bɛtwerɛ letter long letter ɛde aka ho akyerɛkyerɛ Ghana mmara no ani so ɛde Ghana law nankasa aka ho home office sometimes ɔmo yɛ mistake quote law bi ɔmo sɛ yɛ Ghana law sɛ na nyɛ Ghana law nti lawyer no de law no bɛka application no ho ɛne ne letter tenten a wakyerɛw na ɔde kɔ a ne wahwɛ ahyia mu sɛ ɛbɛdi mu nti dɛn na ɛwɔ sɛ wɔyɛ fa Ghana ni lawyer ɔte Ghana awareɛ ase 2 ansa na abusuafoɔ bɛgyina hɔ ayɛ awareɛ ma ɔmo tumi by power of attorney statutory declaration anaa letter a wode hɔ ade aka 3 abusuafoɔ no bɛsɔɛ statutory declaration na ɔmo de akɔ registry ma marriage certificate no bia ɔmɛma wo letter ade aka wowie a akɔ foreign affairs fi foreign affairs a akɔ judicial service if judicial service na ɛba UK a na ebiom wɔde akɔ Ghana High Commission ɛnyɛ ɛhyɛ ba wɔde kɔ a ɛboa wayɛ wei nyinaa akyi no obi a awareɛ no sɔ mbɔɔ ma no ɔtwa awareɛ no ho mfo nti awareɛ no ho mfo ni wɔ yes nokorɛ sɛ baa ne bɛrima no ni abusuafoɔ no wɔ nti na abusuafoɔ no ntwa engagement photo wɔfrɛ no engagement ɛnyɛ engagement ɛyɛ awareɛ ɔmotwa ho mfoni no wie a na woyɛ wɔ application a wode mfoni nso aka yɛ awarehyɛ mu sɛ wodi wei nyinaa nso a ɛbɛdi mu ama sɛ wopɛ advice bi a wobɛtumi afollow BWF Solicitors na wafrɛ ne aboa.
Good morning, good afternoon, and good evening, depending on your location. And then so me ma ankrankrebia akwaba eba yedwumedie so a yato ne de legal hour. Me gidi se ba biara wo ho ye. Wo ho ye de a mesra we ni die mu bomode ana ka me ho ye mfa dwumedie ensha sem free ha. Ye mbo 11 sharp na de abewie ye na mode ewiana bo kama ama nkrofo eni agi kromo ha de saa na tie se wia ne pie saa na ayese brofo akoko aye biomu pu omu pie no na obi ani agi so hu ade no na saa ni je na mesra mo fa nhia me na mfa dwumedie ni nhia se mfiri ha ene onwema kakra ye pese ye de kire na adofo ni ahwefo a mo hwe me mesra ni die mo mombo mo de anhye ade a de be kire mo de yi na topic na nso no eya say definitely no yehu ne eko nti mesrew wo join me a bomode a share program no like the program go to our YouTube channel no so na afi no subscribing so na se ne be ya de bia e ba so a wobenya notification no na wa join ne na yetumi aye program no kama media ne manyete hyiam bia na from na manyete a mejo so jojo ene me resource person me ne be di dwuma ya ye bra penny ye teacher penny lawyer Charles Asma me hia no so di akwaba anase greetings and more than no more yam and made safe for national for now for you mediano ye dear twas or until me mamunina akwaba lawyer Charles Asman Pacha special good morning to you.
Good morning. Good morning. Etiefoɔ ne ahwɛfoɔ echiachia obi biara beebi a wɔwɔ anɔpa yi echia o. Sɛnea n'akaeɛ no ewia no ɛkɔ yie paa. Saa ara nso na nkɔmmɔ no ɛbɛkɔ yie. Nti twɛn yɛsan aba na yɛde abrɛ o. That's it.
Yo, tie, ane kola chasas ma da siye say to nsafra o na audio o say ayo na wa beka ye ho. Yo, ene yendin bone kra say ekro na mesre mo se ne ewia ne bo futo kakra mre ma se na e bo no ye nkasa ye mfa nsuo nhye ye ho. E ya de bia ye bo ye ho nka ye but sometimes we can obeka say na wo de wunnim say or say wo kita nsuo e ya mpa wonim de ba arefre e wo ho ntina me ba won kae ehia pa meni so enra meni so ma obi etwa hweye adentira ewia na hye na ma waye dehydrated na eya areho ye hwehwehwehwe mu a na obi bebre ne nsuo ansa na neni so etete no enti no it could be you, it could be me, who knows, but ne nyina ye ahweye enti efuto kakra me so me de emma etiefo na ahwefo madam asiye mesra mani die mo ba so amon share na program nya kama share, like, and then subscribe to the page. And the topic I want no more de ye na answer na ye di to dwa no lawyers ma ye bia update bi wo ho ana update na saying home office de bia no mo kekan kansem nsem no wo mo ka ye ntia se te se mo ama be kyerɛkyerɛ mu aye bia ye twa ye ho na wotwe aye ba yi mo de bibia betu dwa na
Yo na de bi yɛbɛkɔ yɛnim. Nea yɛnim no ara no ɛnsesaeɛ.
yo ensisa ye dia ne de ne ekɔ yenim ne meka kakra ne se yi visa no ye adwuma nkasa dodro na ye holidays a ye kɔ ye mo amobe mon try to make use of the U visa onya wo de abomode aye wo ye na ntumi nya ko betumi hu lawyer na wafrɛ lawyer bi na waboa o na wetumi ayɛ sisi no na ɛwɔ hɔ sisi ano passport no kra okita wobɛka sɛ bio useless because yi visa na na ne yɛsi share code o sɛ hwan no ɛno a na yɛdi dwuma up and down nti yɛnhyɛ no nso yo lasma yo ɛna a yɛto nsa from producer mesrɛw enidie mu na wode topic a ɛnɛ yɛwɔ no yɛde ato dwa na tiefoɔ no ahwɛfoɔ no ehu no mate sɛ wotie me wɔ radio so a yɛn topic ne yɛ UK visa refusal. Is administrative review always necessary? Sɛ wo kenkan anaasɛ wohwɛ yɛn ade a wohwɛ me ti ase kakra na yɛatwerɛ ne kakraka ɛbɔ hɔnom na nso betumi akan si yɛka sɛ UK visa refusal a na ɛnyɛ visa baako ana mmienu na most of the visas a ɛma ho kwan sɛ wobetumi ato ho anamo sɛ mpo yɛ refuse a ɛno na ɛnɛ yɛka bɛka ho asɛm na sometimes no wakɔ wayɛ wɔ application fɛfɛɛfɛ kama wode akɔtom wohwɛ anim sɛ asɛmpa bɛfiri mu aba wobɛhu a na yɛ refuse wo nso wonim pefee sɛ nneɔma a ɔmo bisa yɛ nyinaara wotumi de atoto dwa de ama ɔmo nanso still a yɛ refuse obi ti saa na ɔnte ase ɔbɛka sɛ daabi sɛ saafoɔ visa na woyɛɛyɛ no sɛ ɛma wo kwan sɛ ɔsɛ woto ho anamo a ɛno ho asɛm nɛnɛ yɛba abɛka no nti ebisa sɛ is administrative review always necessary when your visa is being refused? Enti no lawyer Charles Asman yɛbɛkɔ so na yɛbisa wo UK visa refusal visa ne deɛ ɛdɔɔso yie yɛwɔ thousands of types of visa applications ayɛyɛ na ne nyinaa mu no ɛsiane sɛ woyɛ de kɔ na ɔmo ama wo utibia like your response no mo be ma on nti na ya to visa no ekɔ ene eba ekɔ na eba enti visa bia ye bisa ho saa question visa ben saa na minim sɛ visas no ebi wɔ hɔ a yetumi ma ye bɛka sɛ you don't have the right of appeal na kyerɛ sɛ untumi nyɛ ho hwee ebi nso a yɛnka hwee ebi nso a yetumi ka sɛ you have the right of Appeal. Enti no yɛnhwɛ o mpacho mo lawyer for enimdie mu no visa no sroto nea wahi bi na afei nso yɛbisa is it always necessary say obeye administrative review and mpacho adaroma yetio.
Yo, etiefoɔ ne ahwɛfoɔ, ɛnnɛ yɛ question is sɛ you refuse UK visa ɛbɛhia sɛ wobɛyɛ administrative review anaa ɛbɛhia sɛ wobɛyɛ administrative review anaa nti na host ɛkyerɛ mu sɛ administrative review no koraa no visa biara na yɛde ma anaa sɛ nte saa nti yɛbɛkyerɛ mu administrative review nea ɛyɛ ne visa koraa wobɛtumi de ayɛ na mfaso a ɛwɔ ho sɛ ɛsɛ sɛ woyɛ anaasɛ woyɛ nyɛ obiara nso na ɛfata sɛ ɔbɛyɛ administrative review no nyɛ obiara nso na ɛbɛfata ɔbɛyɛ administrative review no nti na kyerɛ sɛ ɛbɛ saa ɛsɛ sɛ wohwɛ sɛ ɛyɛ is it necessary sɛ wobɛyɛ anaasɛ ɛnyɛ necessary yo nti sɛ ɛka sɛ administrative review a mede bɛyɛ mede analogy bɛto akwan mu na yɛate aseɛ yie. As a teacher mark u paper watchro exams na ya mark your marking ye fail wa wonim say no ade esesa wo pass ye fail nti wonti ase nti na opesa wo ye ne say wo be call teacher no ho na waka chen say teacher ade ya wo mark ya wo fail me nti ase nti san hwe mu biem na your friend no review by review no a teacher no no be review. And I say exam body no omo no review into your friend no administrative review. As I say, now what can you know say teacher no when you use marking scheme no ye into why administrative mistake to fail you. In this home office case worker no or ye teacher or mark you application form no or the marking scheme or your friend no application decision guidance, case working guidance, or there are two. Say your visitors, say your student, say your skilled worker, say your apprentice, FM family, say your den, doesn't matter. Obia won the marking scheme. Enjoy the marking scheme not one or mark here, dear no. Teacher no, all your no be friend no. Into another case worker no, all your no be friend no. Into oba back no, not dream bass no, why a mistake. We refuse to. And now also say, Obi and friend na already marking scheme no one tia say ye into entumi use ye into a refusal. Or refusal na wo hwe ade na say ade say ya ka no no yesa na tie why a mistake there utumi ekopem no say ade no why a mistake say hwe mu biem. And your friend administrative review. The administrative review no home office for no na mbeye review no. Omo no mbesan ahwem but aye am de ma review department referee I wo omo am department ho say referee wo hwem senia ye teacher efelu na wo kwa remarking a ye de ma teacher foforo no the same way so na home office for a refusal visa na wo feel so why mistake na wo call for remarking a omo de be ma another case worker so onhwem na omo ndi sa adwuma no. Into any administrative review, simply a review to correct an error that is committed or made by the case worker leading to refusal. Then your friend administrative review. And from so a case worker here in tia, wama ovisa ye refusal no. A banisa which me kwase omunsanye nhwehwem na omofa yie entu yie. Na administrative review no visa obetumi de aye omo sa akwanya wo ho no eye student visa and student dependent visa, skilled worker visa and skilled worker dependent visa, postgraduate work visa and postgraduate work visa dependent and EU visa and so utumi ye administrative review emane ye. Ne aka ni nyinaa no apart from visitors visas no as I say we appeal visitors visa there, we need right to be we need administrative review, we need judicial review, we need appeal. So now we need a judicial review. Yeah, no asam na yeka. Na yeka na say administrative review no. Ebe hia say obeye and na say ehia. Is it always necessary? And now in review more and a waste of time. The question, when is it good to do? And a breswa a waste of time. So we administrative review. And as I say, case work and why a mistake. And na ye kwese on review. It is why a mistake there. It will not be necessary. So we kwese on review at the no emma. And the best producer now what the administrative review guidance no amaye na yɛahyɛ kwan a yɛfa administrative review no ɛso na yɛhu sɛ ɛndeɛ sɛ na ateɛ deɛ a wode no kɔ a ɛnyɛ yie because ɔmo nyɛ mfomsoɔ biara. Yɛnhwɛ date ɛbaeɛ no date bɛn wɔyɛ volume 11 date bɛn na ɔmo de baeɛ.
15th April, yeah. 15th April, yeah, no more buy.
How many months ago?
Just last month, yeah, a month ago.
Fresh. Me boy. You. And producer kwase content hɔ no nyama bɛn na ɛwɔ hɔ. Ɔmo akyerɛ yɛn changes no. Ɔmo akyerɛ yɛn requirement nti yɛbɛkɔ requirement no.
Requirement, okay. And only requirement near page
50 page what?
30.
And the producer bɛhwɛ yeah.
Okay.
All right. And
Yes.
now boy
Okay.
general requirement.
So, can I say an application for administrative review must be made online at the link at where you ask for a visa administrative review. The link at all. Na link ne title ne ask for a visa administrative review. Na to also can say the fee must have been paid and application made within the specific time limit. Enti de mmerɛ ato hɔ for such application no review no almost say 7 calendar days if detained under the Immigration Act, 28 calendar days if a refusal of an application for an entry clearance, 14 days if a refusal of an application for permission to stay in bracket where the person is not detained. Next one here, 14 days calendar if a decision to cancel permission to enter or to stay at the border in bracket where the person is not detained. Now, okay.
Yo, enti yehu sɛ ɛkɔba sɛ ɛyɛ necessary sɛ wobɛyɛ a ɛbere ɛda ho. When di bere no so a asɛm ato. Sɛ nipa no refuse no visa a ɔde ba UK a wɔ 28 days. Nipa no refuse no visa a ɔde tena UK mu a wɔ 14 days. Sɛ nipa no yɛ detainee no a wɔ 7 days. Sɛ nipa no obedu airport na ɔmo detainee no a wɔ 14 days. Nti bere no ehia pa. Ubetu application fee £80. Na wa submit your application. Ɛyɛ online. Nti sɛ wokɔfa paper. Wokɔhu pocket lawyer bi ma no kɔfa pocket paper bi de ma wo a na wotwerɛtwerɛ so de kɔ a ɛno no ɛnyɛ administrative review form. W'ani bɛba wo ho so na tam no so atwam. Afidie abɔ. To mention no so ɛyɛ online form. The next one na
Into late application paragraph AR 2.14 no can say the application is made on the date if or say the application is made on the date it is submitted online. Applications submitted after the deadline has expired must normally be rejected. The only exception to this is where the Secretary of State is satisfied that it will be unjust not to waive the time limit and the application was made as soon as reasonably
Practicable.
practicable.
Okay.
Patrimental also.
No, yeah, nkyerɛ mu a say. Enti obi wɔ mu a ɛnsɛ yɛkyerɛ mu sɛ application woyɛ later wontumi
And
ɛnfa nkɔ.
submit. Yes.
Na obi so mu a wiase no yɛwɔ law na yɛwɔ
Okay.
common sense.
Mm.
Common sense ne sɛ yɛde toto ho a nipa no yɛma no chance because nea ɔka no ɛtɔ aso mu.
Mm.
Nti ɛde sɛ woka sɛ woayɛ late na mmom wowɔ nnyinasoɔ na
Mm.
yɛagye ato mu ama wo. Yɛfrɛ no extension of time to bring administrative review or submit administrative review. Nti sɛ wɔ
Okay.
explanation no ɛtɔ aso mu a yɛbɛgye ato mu. Bi a decision ne baeɛ no na woyare seriously. Wo ho tɔ waa na wode kɔɔeɛ ɛtɔ aso mu. Reasonably practicable no bi no. But what aseɛ?
Okay. Make it sense. Mm-hmm.
Ebi so a na home office for ewie wo decision no, ɔmo tena so a, ɔmo de brɛ wo saa da no na ɔmo de brɛ wo. Saa da no so na wo so kɔpɛ lawyer. Saa da na wonya advice. Nti na the next day na ɛsɛ wode kɔ. Nti na just apa ho dada. Nti ɛyɛ hwan fault?
And
Ɛyɛ
your
ɔmo
home office on your fault.
a. So the moment you became aware and you submitted, it's reasonably practicable as soon as you became aware. Nti ɛno so ɛyɛ exception no bi no. Nti woba wontumi nka sɛ na menni £80 ɛne deɛ ɛnyɛ reason.
And your reason.
Anaasɛ na me computer ɛnyɛ adwuma. Anaasɛ na menni internet. Anaasɛ na me nsa bɔ retwa nti na mentumi mfa ntaapo.
And
Ɛne deɛ
then
aha.
and as
Alright.
you say, and so no, you post to then you online.
Ɛyɛ online.
Bibia ye online to me can say you post to ye no so nsa nka ne ntam.
Anaasɛ na mennim sɛ ɛyɛ online nti mekɔfa paper bi na mede yɛɛyɛ. Na
You
akyire
don't have
ka
such
sɛ
reason.
baby ɛnyɛ good excuse.
Okay.
Nti
So let's continue then. Sorry.
sɛ woyɛ administrative review a Bible no anaasɛ Koran no ɛna yɛde ato dwa no yɛfrɛ no guidance for admin review.
Okay.
Yo, call the next one.
Yes, so the applicants may need to provide
No,
a
don't worry.
claim.
Leave that
Yeah,
side.
no.
And go to the next one.
Yeah,
The next title.
And
Okay.
restrictions a paragraph administrative review 2.8 to 10 and then 2.15. I say only one application per decision is permitted unless the decision is upheld in an administrative review for reasons which are not different from or additional to the reasons previously given to justify the decision. In such cases, the revised decision may be challenged by a way of a further application for administrative review. Patramenko so.
Yeah, and you had an opportunity in answer. Won't mean your administrative review and now next week, Obia Kacha say, oh, in case we any say. Now say, oh, when you miss I full fraud yako. As if say a snack. Now Condra no AGB. And this
Okay.
nti yɛ baako a ɛkɔ nti woyɛ a ɛbɛbisa sɛ has administrative review already been submitted nti woyɛ no baako nti woyɛ a wonim sɛ woyɛ na wayɛ no yie because ɛkɔ a ɛnoa no no
No.
ɛna sɛ wosan yɛ foforɔ a wansa afi dɛ akɔsesa na ɛwɔ hɔ dadaa no na wayɛ overstay a depending on sɛ wo visa ɛwu dadaa hyɛ no no nso ɛna ɔse if
If the decision challenge is on an application for entry clearance, the person can only apply for a review if they are outside the UK.
nti obi wɔ mu a wayɛ entry clearance application refusal ɛna refusal no but nipa no sɛnea yɛka no entry clearance or outside the UK ɛna decision a ɔchallenge yɛ no of course ɛne ne outside application ɔsɛ obetumi ayɛ but wei no of course yɛwɔ application biara a woyɛ no ɛne nea wobetumi ayɛ sɛ admin review is allowed or not. Nti ha na ɔse if the decision challenged is an application for entry clearance, the the permission, the person can only apply for review. It's not always, yeah, of course, if it is review, that thing is online. In the
Uh-huh.
whether you are in country, whether you are in the UK or you are in the US or you are in Ghana or wherever you are, it doesn't matter. Internet in there is already online.
Yeah.
Internet is already outside. But no more can in an sense, oh, yeah, administrative reviewer. Won't mean can say, oh, UK, Abra, only UK.
Mm.
So you have to specify where you are doing it from. And that's why they are saying that if you are outside the UK and you made the application and it was refused, you have to do it from outside the UK. Of course, you can only do it from outside the UK. Until your matron or Hanon Grampo there, and it doesn't make it's not necessary.
Mm.
Yeah, it's not
Okay.
necessary. The next one I'll say,
Dependent, and I mean, paragraph now.
maybe another if one
Okay, so if the decision challenged is on
application for
application, yeah, application for permission to stay, the applicant was in the UK when Mpacho Mamin Kana Mintia Semianso. So if the decision challenged,
now oh yeah obi a ọwọ UK na wayɛ
aha,
application wey refuse no na bi a wekɔpie another country na ɔsɛ ɛnna
country,
yɛ review na efi hɔ wontumi.
on to me, okay, all
Nti
right,
sɛ wowɔ outside a wobɛyɛ efi outside, wowɔ
outside,
inside a wobɛyɛ efi
obey
inside.
inside,
You can't do it the
okay,
other way around.
that's correct. So where the eligible decision is made in a control zone, and only control zone, for example, Eurotunnel or Dover, a person cannot apply for administrative review until they have left or been removed from the zone. Nti no no what I say am I now yenko.
Ɛne yɛ different. Ɛha
Oh,
no yɛ
okay.
different. Ɛha no yɛ obi a yɛka sɛ control zone a ɛyɛ
Mm-hmm.
detention zones.
Right.
Nti obi wɔ mu a wɔbɛpie ɛnso ɛka sɛ yɛdi
Border.
10 a wowɔ 7 days to do it meboa.
Yes.
Nti obi wɔ mu a yɛdi 10 no na ɔno na ɔpɛ sɛ ɔyɛ sɛ woa na ɔpɛ sɛ ɔyɛ a wontumi nya system no wɔ hɔ na womfa nyɛ unless obi yɛ ama on your behalf. Nyɛ saa deɛ agye sɛ wopie fi control zone hɔ no na woatumi ayɛ. Na wei nso po deɛ mfasoɔ bi a ne ho sɛ ɔmɛkyerɛ wei because at the end of the day no sɛ nipa no wakyekyere no a ɔbɛyɛ dɛn na wayɛ adeɛ no.
Obede no waye. Nti so
Ah,
obi aye ama no,
obi
right?
ayɛ ama no. Nti mfasoɔ
Aha.
ne sɛ ɔmo waste ink ɛwɔ ha sei. Ba wo deɛ yɛnkɔ yɛn anim.
Okay. Now, yenko dependence ne so a person P maybe a person P net or the din bi na ahye wa amaye na
Ɛyɛ nipa no a yɛ refuse no visa no.
okay. Na yenti ase. Okay, a person in bracket P may apply only include an eligible decision for a partner, dependent child or other family member in the application for administrative review where one of the following applies. Enti no, nea ɔka no, yɛnhwɛ what applies. No, say
Okay.
one, that family member was a dependent in the application which resulted in the decision which P is challenging. Okay. And then two, that family member was previously granted permission to enter or stay as a dependent of P, and that permission is being cancelled at the same time as P's permission is being cancelled. Okay.
Nti wɔyɛ obi a yɛ refuse no na yɛ refuse no dependent yɛ refuse ɔmo nyinaa nti wo main person woyɛ wɔ administrative review a wobɛtumi de wo dependent no deɛ no ato the same form no so ɛna obi so mu a yɛ cancel ne visa te sɛ kɛɛkɛɛfoɔ yi yɛsɛ wakɔ yɛ cancel wo visa nti yɛ cancel wo visa na yɛ cancel wo dependent deɛ yɛsɛ wokɔfa wo baaba ɛna wɔkɔtwa ntorɔ nti yɛ cancel adeɛ no yɛ cancel dependent deɛ nti ɛkɔba saa na wokɔ administrative review a
Now the ɔmo nyinaa aka ho.
wode obi a affecting me biara nso ayɛ dɛn ɛhyɛ mu bi.
Aka.
There's no point sɛ wobɛyɛ no maako. You do it together. All right.
Hey, administrative review so who wants some? Yo, young waivers and fresh applications. Enti no, nea ɔka ne say if the applicant previously signed an administrative review waiver form in respect of the eligible decision, the administrative review is not valid and must not be considered. Now, wasama and see the waiver form below. But
Okay.
say
Yes. So explanation, I want to say, obi umo a na oyen application we know ye obi umo our restrictions. Oyen application na wa sign say you refuse me mean to me I agree I will not apply for administrative review. That is the way we view right to admin review. So we view right. Now if you cannot exercise that right. And
Oh, okay.
the can in says, "Oh, your application." Now I can say, I I want to. I'm filling this form that if I'm refused, I will not seek administrative review. Don't fill that form. Otherwise, it will go against you. So no more pay action or but most
Um,
people we affect you. Most people now affect you. I think we know it doesn't apply to them. So we move
okay.
on to the next one.
Right. So if a person who has received a decision, that's D, which is eligible for administrative review under paragraph AR 1.1, makes a subsequent application for entry clearance, permission to enter, or permission to stay, any application for administrative review of the decision made after that subsequent application is not valid.
Okay.
Home office, mo bro, yay.
I
This is
mean, now I say, I say, so be reading the bill more. If a person who has received
yes.
the decision, it is why you apply, why you are there, no amount decision.
Mm.
The amount decision, obey then was not administrative review bill.
Uh,
I don't know why you amount decision. It is
decision.
administrative review no and year. You have to move on to something else.
Mm,
You don't put in another administrative review.
mm,
Otherwise, the second administrative review will not be valid.
it will not be valid.
Because you cannot review administrative review decision.
Decision. Uh-huh.
Yeah.
It's one of the questions I put down, but it's been answered. Yo, ain't no yen nim producer for cost kakrama me na yen share free and payment exemption. Patro
No,
yen chias wo.
let's leave this one. Fee need the
Oh,
£80. Ubetia.
mm,
Unless there were exemptions, but let's not worry about this. Fee
that's okay.
waiver. Fee waiver so when you say about ebe move on.
Mm.
Refunds, ebe move
Na
on.
say anye yi a ye refund o.
And I say say ye refund one ye they are
Yeah,
refund.
we see car came. Oh, okay.
And
I know
say
me.
I don't wanna una wo challenge you almost my mistake. Nti say wunwini a so mutia ma wo. And it
Mm,
also follows civil procedure rules. Yes,
mm,
yes, civil procedure rules CPR 44. CPR 44 or say
mhm,
only be 3 months so na wunwini a
mhm.
na we win na say nipa no a we lose no tia wo kama wo.
Okay, uncle. Oh, yes,
Yes, I mean,
yes.
no, but na me tia £80 na me win ya say utia me kama me. Nti sɛ wo win administrative review a ɛsɛ sɛ ɔmo refund wo £80 no ɛma wo.
Then, mommy. Okay.
That is
It
sɛ
makes a
appeal.
lot of.
Appeal nso sɛ wo win a wo for £140 no yɛde
How
ma
much
wo.
be now?
Na judicial review nso wo win a ɛka a wobɔ yi biara no so ɛsɛ ɔmo de ma
How
wo.
much be now? Yeah, tears here. Okay. And you know, yen share way so. See, claimed
Nti aha
error.
no aha no hia paa.
Mm,
Whether
mm.
it is necessary
Or
or
not
not
necessary.
or not
It's here.
necessary to pursue administrative review depends on whether you are right or wrong. If you are right, will you go and fight? If you are wrong, will you go and fight? Now, maybe so asem.
If I'm right there,
No,
and
if you are wrong, will you go and
no,
challenge in it? No. And
there
if you
be.
are right, then you
Yeah,
go strongly to challenge.
that's correct. Mm-hmm.
And so there's maxim in equity.
Uh-huh.
Or say if you want equity, you must come with clean hands. Meaning so what is that now?
That's
He who
correct.
He who wants equity must
Equity
come
must
with
come
clean hands.
clean hands.
Wow, wait, what for? What for?
Mm-hmm.
How fake document? And you
Mm-hmm.
refuse to adhere. Why you adhere ni ye? You refuse to
Uh-huh.
adhere. Why you see us now? Who you see no? And your
And
papa
yeah,
you
Papa,
refuse to. Why your
what's the
application? One
complied?
first US and come you refuse to. Why your application deadline now? Pa who you refuse to. Now we say who have a challenge. It assume
And yes, and that's so.
very good because your hands are not clean.
Mm.
So if you
And
want,
that's
into may can say whether you are going, it is necessary to pursue administrative review or not. You
mm.
have to check what you are challenging and whether there is error in the first place.
Mm.
Into Yanshe, please start.
Yo, nti nea ɔka ɛwɔ hɔ anansɛm a ɔka esi so. And it's administrative review will only consider the following case working errors, which are specified in the in appendix administrative review of the immigration rule. Mommy who say Yankai say lawyer Charles Asma akyerɛkyerɛ mu sɛ ɛyɛ errors a wowanya wo decision no na wohu sɛ error wɔ wo decision ne mu ɛno nti na wopɛ sɛ ɛyɛ administrative review nti no ɔmo nso ɔmo kyerɛ adekode a ɛbɛyɛ error ɔde ama wo nti a wobɛtumi akɔgyina so de akɔyɛ administrative review nti patro mommy yɛntie ne yie.
Yeah, na you put in another way.
Okay.
Yankyerɛ mu bie mu obi badwin sɛ ɛndeɛ sɛ wohu spelling mistake a wode bɛkɔ for administrative review. Ɛnyɛ error a ɛwɔ refusal decision no na mbom error a ɔmo yɛɛ nti a ɔmo refuse adeɛ no more or less ɔmo refuse adeɛ no by mistake.
Okay.
Ɔmo ayɛ mistake na ɔmo amfa ama wo. Nti sɛ wohu sɛ ɔmo ayɛ mistake a then na ɛma wodwin sɛ ɔmo ayɛ mistake.
Mm.
Because wonim sɛ exams you were passing na yɛ
Yes.
fail. Nti so no ade wei deɛ the way I metro no I have to I will go for remarking. Nti wo nso wonim sɛ woyɛ your application you followed the requirement. Ɔmo say provide this, provide
What
this, provide
provided?
this. You did everything right. No more refuse you. You are 100% sure say there's something wrong. You identify that mistake, then you go and challenge on that. And so
Okay.
what are some of the errors?
Errors. Okay. Mintro ento hana obi wo question wo sa ohono. Or say the original decision was incorrect. Paragraph AR 3.3A no and B and was a decision to refuse or cancel entry clearance or permission to enter or stay under part suitability of the rules in bracket false representation, false document or false information or failure to disclose material facts or previous breach of condition.
Okay. So example ni home office no refuse so no no actually me say your application has been refused because the caseworker was not satisfied that the document he submitted is genuine.
Genuine.
Ebi a na nipa no use COS. No mo say COS
Okay.
is not genuine.
Mm,
Nipa yi so COS no company legit company na ɔde maa no.
mm,
Nti wobɛkɔ company ni hɔ nti na obi say nkurɔfoɔ no say ade na ɛyɛ no COS na ɛyɛ papa. Ɔmo say no it's correct. Look,
mm-hmm,
ɛba saa wowɔ ahokeka sɛ no the people are wrong. Adan ɛnde obi ɛsɛ ɔmo use obi deɛ na ɔmo de agye
mm,
bi. What I say?
mm,
Because you know say documents that we use you know information I would more no on the application form bibia 100% correct. That then to make us say we use wrong information, false information or false document. A basa you can challenge them that you have refused my application because I have used false document or false information. There's nothing on my application form which was wrong, and none of my document was also false, and therefore you are wrong. Then you are challenging them on the basis of that part.
okay. Na just say no na obegyina so. Okay, now see second one so the original decision maker otherwise applied the immigration rules incorrectly, and paragraph AR 3.1A no.
Okay, nti edi kan case worker na yɛ mistake because ɔde obi asɛm abɛyɛ wo asɛm egyina so refuse. Ɔmo yɛ saa mistake no.
Me question
Ɔbɛsa
back no.
which me challenge ɔmo sɛ masa adan na wada na wode obi information wogye sɛ meyɛ kwesi ata wode even idin a wokyerɛ no koraa ne kyerɛ sɛ yɛ kwesi ata na wakyerɛ no anaasɛ wode nti more or less wode obi information
Information na abama me decision.
ɛna abɛde ama me decision nti saa nipa no a yɛ sɛ refuse no wode ɛbɛ refuse me nti ɛkɔba saa you send your admin review challenge under paragraph AR 3.3 or wobɛtumi so ayɛ no sɛ bia na case worker no anhwɛ mmara no yie nti apply mmara no wrongly to make a decision ɛno nso wotumi ɛkɔ challenge wɔn nti yɛbisa yɛn ho sɛ is it always necessary to challenge? Worker genuinely has messed up the information,
And yeah, you have to.
then you have to. If it is true that the information is yours and they have refused your application based on your information there, do you have to? You don't have to because they are right. So it depends on what has happened. That will call for administrative review. So it is not always necessary. So we challenge you, but when it's necessary, you have to challenge.
You have to challenge them.
That is the only remedy.
Okay. And then lastly, I see the original decision maker failed to apply the Secretary of State's relevant published policy and guidance in relation to the application. I'm saying yeah, was I abortion. Let's just say, okay, lawyers man patch.
Oh no, I say the original decision maker
failed to apply
the Secretary of State what?
Policy and guidance. No? Yes, one share guidance note.
Guidance in relation to the application. Edi kind no application requirement no. Application requirement or see failed to apply the immigration rules. The immigration rules no application requirement no. Or say provide COS. When provide COS, you refusal. So when provide COS, you refusal, and some way are correct, because the law says that your application must be submitted with COS if it's a skilled worker visa. And I say you must provide evidence that you are married. All those things. But second one, in addition to the immigration rules, there could be some other publication at Home Office that about say, as a song share. Obi man is COS no ewu. Sorry, Obi man COS no company no enye ready. And our application no. Your application no and now or the letter to so say the company no or Chinese COS Home Office a delay and Jeremiah. One train and we refuse no. That means even though nipa no correct to say case worker no right to say when provided COS within the immigration rules, but are wrong not to wait for the COS issued by the Home Office because policy guidance be say company no Chinese COS the applicant application must not be decided quickly. Until Home Office no release COS number company no their money panel many parent their common. In just one year even though you are right under immigration rule, say nipa na first COS, but you are wrong under existing published guidance. Yeah, so that is the difference.
But no, maybe a question before you be moved to. Has there been any application based on this COS thing now without say train application no train COS from the company and now from the Home Office, via your company no obetumi aye application akwa na say
Yes,
eno
Sana.
omo
Sana omo aka.
omo ka
So what officer ewu na o company no air train the COS. Na your home office. Your
okay
home office na a delay or more.
omo
You don't have to
that's
wait.
correct.
Submit the application and they'll give you 3 months to provide the
Okay.
COS.
Oh, meaning
But
say
you need a
bibi
letter from the company. You must provide a letter from the
letter from
company
the company.
to support
Okay.
the fact that Omo Chan COS.
COS. Okay. And then follow up on that, no. Say ewo ho na mo train na embia omunye refusal into no omo fault. So maybe you've done the administrative review and then upon waiting, no, then no home office for so a refusal company no same bia omo ampasi omo due diligence and I say bibi into no yɛama ɔmo COS no yɛama ɔmo permission no anaa license no a ɛno saa no na kyerɛ sɛ automatical administrative review no ɛnkosi aga ɛnyɛ biribi saa.
Aha, bibi sa but mefa because yesu amra nti mefa mra bi metwam wa ha.
Okay,
Eso ade ne nkomo a yedi nyina is about fairness meboa.
fairness, that's correct,
Fairness.
yes.
There's another principle in fairness.
Mm-hmm.
Or say equity.
That's it.
Equity treats as done that which
Okay,
ought to have been done.
right.
Nti sɛ nka nipa no de COS no kɔyɛ a
Uh-huh.
because your application no was submit one first COS na nkɔ
Anka. Mm-hmm.
anka ho na company no wosi wo twɛn na company no ya refuse ni COS no
Mm-hmm.
ana mpo sɛ ya cancel ne
The
sponsorship
license. Mm-hmm. Mm.
sɛ nka saa decision ba ntam a nka obetumi ayɛ application no
Nka
sɛ nka
untimi nya
wobɛtumi
play. Yes.
so it doesn't matter sɛ ɛba
Mm.
ntam anaasɛ amba ntam yɛbɛ
Amanta.
refuse na ne sɛ yɛ refuse
Okay.
esi wɔ a
Esi Hey, I'm right to the more lawyers. I'm going anyway. We are lawyers.
You have to know say, oh, I'm challenging it because you have refused my application. And I will see me company no crown, so you was in farm. Adentina, one may be say, me family and sign that doesn't really matter.
Matter.
You
Okay.
know who control company in COS.
Exactly.
You know, say I'm farm company no. In this year, refuse you near trust say your company's COS request has been refused or your
Refuse.
company's license has been
Has been
cancelled.
revoked.
On what basis are you going to challenge this? I didn't know what kind of sir. We are
Okay.
right.
We are right. So
This is it necessary to go for administrative review?
you wouldn't go for
Not
administrative review.
necessary. So
Not necessarily.
it is always not necessary to go for admin review
If
if
you are
what's
wrong.
in there. So what's something there, don't
Yeah.
go.
Then all right. Hey, yo. Yanko anyway na yankan ne etua ho no na afedie. And I say last one no a ebesi ho na yanko so last one e wo.
Oh, you call the next you move on.
Okay.
You move on.
Enti
Producer, go to the
right.
next one. Okay, into Hano on my descriptions be case working error. Example, Anna, can the reviewer request relevant new evidence? Until when the evidence can be provided later, and when the evidence cannot be provided later. Let me give example. Until I describe it table no near all patch young go through. Obi omua or an application no. You say provide evidence say wone wo yere anase wo kunu eneti because subsisting relationship meboa and other application no call ye one first evidence na nka ho na ye refuse no na case worker na akere mu say we have refused your application because there was no evidence of subsisting relationship and therefore you cannot apply as a partner na wakwa evidence no and other aka na administrative review no ho me question am be bisa oni say saa evidence no ɛkyɛ sɛ wotwɛn sɛ wode bɛkɔ administrative review time anaasɛ time a woyɛ application na ɛsɛ wode kɔ na
Send your time our application now so they call.
Ama we application as a wode call. Just one phone call. In your fee na wode be call akwakyerɛ mo say na me
Okay.
wadada. Into I say at that time you cannot provide new evidence. Into
New
actual no.
evidence.
Actual no.
Okay. I
But
see. You
but
see,
where the original evidence is being
mhm.
is an I say where
Where
the
the
original
original decision.
decision maker read the one.
Or see where the original decision maker's decision to refuse an application under paragraph SUI 10.1 on the basis that the supporting documents were not genuine was incorrect paragraph AR 3.3A no.
Aha.
Into an example.
Nti ye o de yɛmfa another example. It was about when I kai and you say nipa no say or marriage certificate but so na wamfa nkɔ.
Into
Afi
non
na
to
ɔde bɛkɔ. Don't you mfa nkɔ at this stage. Second
mm,
one no nipa no the marriage certificate no kɔyɛ. Na ɔmo say ɛyɛ fake. Nti ɔmo refuse application no.
mm,
Ɛna wakɔ government na ɔde ma o issue certificate no.
mm-hmm.
And the government actually said no, this certificate was valid, so they are only provided verification letter.
Okay.
And at this stage, in order to meet the verification letter, now then because
Aka ho.
you are using it to prove it say no more
Ɛyɛ
cano
genuine.
and yet and to assume that's
Mm,
the difference.
okay, that's good then. Nti yɛnhwɛ third one no nso no. Ɔhɔ no ma membisa question bi, mmere no nso kɔ, but membisa question bi wɔ hɔ. Sɛ ɔmo ka sɛ ɛnyɛ genuine, te sɛ COS issues yɛ biribi a bɛtɔ yɛ nim. Company no yɛ genuine, COS no yɛ genuine, but the figures and the numbers written on na ɛm sɛ ɛkɔyɛ typo error kakra. Nti no, ɔmo de kɔɔɛ no, ɔmo sorry, ɔmo sɛ COS no nyɛ sorry. COS no nyɛ genuine, ɛnyɛ nokorɛ. Ɛna afei nso company no sɛ ɛyɛ nokorɛ nti no ɔmo kɔ mu no ɔmo kɔ ɛno saa no ɔyɛ administrative review no na company no ɛyɛ sɛnea ɔkan sɛ review anaasɛ ɔmo correct mistake ne sɛ ɛyɛ genuine COS but it was a typo error na ɔmo de ka ho a ɛno no mpatwɔ obetumi agyina so na ɔde ayɛ administrative review no.
And no support the fact said
Mhm,
COS no correct.
mhm.
Because almost COS no correct.
Ɛnyɛ correct
Muchim say you're correct. Nema no ekoba no sa no say bia typo instead of SU. Omo ye US.
biribi saa
Ina akoba no sa but an interest says COS no fake. Yes, we
okay.
provide this are supporting new evidence. Since that new evidence, it's not
Mhm.
providing evidence, but it's
But
clarifying the
the
point.
old evidence, you know.
Uh,
Okay, okay.
clarifying the point to say, and you're wrong, but it is.
Um,
Uh,
okay, you. Now, young queen, must see where the original decision maker's decision not to request specified okay, specified documents under paragraph 245AA of the rules, that's point-based system evidential flexibility, was incorrect. Paragraph AR 3.3D no. Nti ɛno no sɛ producer call from
okay.
kakra.
And see, ahano obi omo a wire application. There's something we call evidential flexibility. Evidential flexibility in say, you can't check case workers and say, and prepare who
Mhm.
and could make a decision. So when you're sure,
Mm.
my providing my bank statement.
Mhm.
As I said, me provided 6. Yes, sir. Na me
Yes.
provided 5.
5.
Nti, ɛno no, sɛ wohu baako no a, common sense, wɔnyɛ law, common sense.
Mame ho kwan na fa baako ne mbra.
Ɛndeɛ, mekɔbisa ne sɛ, baako no ɛwɔ he?
Ɛwɔ he?
Ebi koraa na ɔdwen sɛ ɔde baeɛ, anaasɛ ebi koraa na akɔhyɛ baabi.
Ah.
But sɛ mamfa bank statement nyinaa amma deɛ a, ɛndeɛ you don't have to come to me to ask for bank statement.
Mm.
Because I knew, say, I should have provided a bank statement. But I mean, the bank statement no nyinaa aba. Na
Ah.
baako bi koraa de wohu ne yie. Me the 6 na ba ya ba baako wohu ne yie. So I didn't see it properly. It's a refusal. Come on, that's harsh. So what do you have to do?
Yes.
I replace it for you, or I give you a clearer one. That is called evidential flexibility. It is a case where can follow some rule. No. Now one year necessary no writer, no refusal. You can challenge under the fact say they refused to apply evidential flexibility rule.
Okay. Yɛate hɔ no ase. Yɛnkɔ yɛnim kakra. Mpakyɛ ɛfa kɔ soro kakra ma me ne yɛnhwɛ the fourth one. Ɔse where the original decision makers, I'm sorry, where the original decision maker applied the immigration rules incorrectly. Okay, and also ɔse no. Or apply incorrectly. The caseworker refuses the application because a resident labor market test has not been carried out, but the applicant's occupation is exempt from this requirement. Last man,
And I say where the original decision maker applied the rules incorrectly. I mean, so rule no incorrectly, no, and then the church, no. For example, you say under paragraph CHI 3.1, 3.2 of Appendix Children to the immigration rules, with respect to paragraph SW 32.1A of Appendix Skilled Worker. If you are bringing your child to the UK, you have to show that A, the other parent is dead, or B, the sponsor parent has sole responsibility, or C, there's serious and compelling family circumstance. Na nipa no a akwala na akofa na aba na papa ewu, ti maame no kwa na oye parent. Na ọchọchọ mi sẹ mi ana mehwẹ me ba me yese. Na woyɛ caseworker no make a decision or say we have refused the application because there was no sole responsibility. Meanwhile, there's a sole responsibility or say dead. The other parent is dead or the death certificate at also. You don't have to jump to sole responsibility only. You have to look at the fact say because the other parent is dead, the surviving parent automatically has sole responsibility. Correct application of the law. In the case where cannot missing or conclude say, we say one kwana we shall no we have evidence of sole responsibility. And we go and challenge them to say, hey, one tears here. Or say akwala papa we woo into no kwana or shall certificate say we would only need. Emrano says akwala papa would dear and the automatically me no tears no shall into
so responsible.
I say akwala no qualify say obaba join maame no, not because of sole responsibility, but because the other parent is what dead under A, not B. So you see, these are the nitty-gritties of the law. In this case worker no omo ye nimpa, omo making mistakes. Into no anti ase a obe making mistake. Into wo no a we lawyer, wo ye pocket lawyer, we lawyer papa no. It is very well. Obeti ase say no, omo ye mistake, and you go and challenge them and you quote the rule. Say, under paragraph AR 3.1A of Appendix Administrative Review Guidance, or say refusal that say okay, so we say, but we wouldn't say you are wrong. You applied the law or the rule incorrectly. In this case, you don't have to provide new evidence because it's not about evidence. It's about what?
It's about the rule, law.
Yeah.
Wow. Okay. Right. Yɛnkɔ yɛnim afei ɔse where the original decision maker incorrectly added up the points to be awarded under the immigration rule. Okay.
I would say, yeah, well, under point-based system, you have to score points. For example, students, okay. You have to score points for CAS. In that skilled worker, you have to score point for COS.
COS, that's correct.
in English, so best score point me boy.
Sir, yes.
English nso yɛ wɔ specific English.
Na omo hwehwɛ.
And case worker no instead say best score the right point no yɛ 30 no. Ɔno
Uh-huh.
dwen sɛ ɛyɛ 31. And
Okay.
because ɔde one beto so no nti nipa no fail point total no.
Okay.
That's a case worker na wa exaggerate yes sir.
Why on why mistake no?
I don't know why a mistake.
Nti
So
obetumi.
they argue them say masa now they wouldn't matter na. I don't know 30. Why you 31? Uh-huh.
Na sɛ nkae neɛ sɛ 31 a sɛneɛ nkae more nti nka wɔ sɛ nkae neɛ ɔmofa ne saa o.
They
Nso
because on no gene say 31 it's nipa no end do threshold you know.
aha, okay.
Yeah.
All right, that's
Say
correct.
added up the
Up,
point.
nti na kyerɛ sɛ
It's
30 na me kita no wo sɛ 31 nti na kyerɛ sɛ mendu nti no
very good.
ɔsɛ okay. Hey, case workers nti na ɔmo kɔ training a ansa na ɔmo akɔtena adeɛ akyi. Okay, producer focus soro kakra na yɛnhwɛ the next one na afei deɛ. See, where the original decision maker has not considered all the evidence that was submitted as evidence in the eligible decision paragraph 3.1 ARA. No.
Good. So I have a example. Example nini. You have student visa dependent and your example. Student visa dependent, you know, Oma cancel for dependent, meboa.
Yes.
As far back in June, June, in July 2024, no more cancel here. However, almost say nipa no all year student, you know, so or the sponsorship na or the bar, na scholarship na or the bar. Obey to me the dependent account.
Account.
That's an exception. And na me year student, na me kwaji visa, I'm under scholarship, government scholarship. To me the independent in our account. Case worker no one team run say into we refuse to all my dependents. No one since July 2024. The law says that you cannot bring your dependent if you are doing 1 year master course.
Okay.
But that is wrong, my boy.
Yeah, that is wrong because
Evidence no includes me scholarship document, you know.
just say me
It
to me
is
the
so say a scholarship document, name of your personal bank statement, go be who say me dependent qualify.
effort.
That's the difference. Until where the evidence are not all considered, we find it in a way Johnny
We
Akano.
that near no okay.
We used to not as here. In an chance to baby. The first I want to ask you, and when you see in an interest, you are right. We'll challenge it.
Okay. Yɛate ɔno ase. Na yɛnkɔ say where the original decision maker has considered where the original decision maker has considered some or all of the evidence submitted incorrectly as evidence in the eligible decision. Hey. Wafa bi na wagye bi.
Similar to the first one. Yeah.
Okay, no just say
And
no.
some say, yeah, church, sir, when your decision. Now, when him say no, error ya almost error use ye versus the when you move so make a decision and you have to pick the error no. Who picking up you can then challenge them within the rules. But who pick error no na eto assume will you still go and challenge them?
No, won't go
No.
on challenge.
So the question is it always necessary to seek administrative review? It is only necessary when you are 100% sure that there is a case working error.
Error.
When there's no case working error on the part of the case worker, the decision is right.
It's
Another
right.
example. Obi Omobefrel, hello lawyer. My spouse made an application as my dependent. My children, COS, dependent, they have all been refused. I want to go for administrative review. Can you do it for me?
Why?
The first thing I will ask is, when was the COS issued?
Issue.
The COS was issued from
Previous
11th of March 2024,
for any.
and you cannot
Mm,
add your dependent. Any number one.
yeah.
Number two, what is the COS code? Because
Mm,
6.61, six
uh-huh.
one three five,
Mm,
and 6136, you cannot
mm,
add your dependent. Meboa.
depend. Yes.
Na nipa yi a ɔfrɛ mi, okonya ne
Mm,
COS January 2026.
mm,
Ɛna ɔyɛ no application no, ɛna ɔsucceed yɛ.
mm-hmm.
Ɛna ɔkɔyɛ ne mba ne ne yere deɛ nso ama ɔmo, na yɛ
Yeah,
refuse ɔmo.
refusal. No.
Ɛna
Okay.
ɔse ɔkɔ administrative review. Nti me
Mm.
lawyer menyɛ ma no.
For
Do you, do you
enter
think
so
so? Do you think sɛ minim adwuma a mɛgye saa adwuma no ayɛ?
there we own yet because
Adɛn nti no?
date no kyerɛ sɛ wontumi mfa ne dependent ɛnka ho.
Because the case worker is right, and so
It's right.
administrative review is not
It's not
necessary.
necessary. Yeah.
Yeah,
Mm,
because they are right to
mm,
refuse you. They
mm.
did not make a mistake to refuse because the law is clear
It's
and they
clear.
applied it correctly.
Nti hɔ no ansa na yɛbɛkɔ so no question baako apɔpɔ ɛm sɛ me question na mebisabisa no ɛno saa no example a wode maa yɛ ɛyɛ case ɛyɛ COS yi na ɔnya ne COS no ɛyɛ yɛfrɛ ne sɛn old one ne bi before 2024 no na ɔde ne wankɔfa ne yɛfrɛ ne sɛn ne dependent number but na ɔwɔ saa old one ne bi nti wabɛtwa 3 years na ɔkɔgye another COS a ne company no bɛma ne company no ama nti ɔkɔnya company foforɔ agye COS no but nea ɔkɔgyeeɛ no ɛyɛ neɛ yɛse sɛ ɛnɛ neɛ ɛde ma wo a yɛse wontumi mfa wo dependent ne nka ho. Does that mean sɛ ne dependent na ɛwɔ fie no anka first one no ɔwɔ ho tumi sɛ nka ɔbɛtumi ne ɔmo aba na ɔmo amba no na nea wakɔgye foforɔ no ɛkyerɛ sɛ ɔntumi mfa ɔmo mba koraa anaasɛ the fact sɛ ɔdi kan anya neɛ ɔwɔtumi sɛ ɔde ɔmo ba no ɛno nti still a ɔbɛtumi akɔfa ɔmo aba na mpakyɛw menim sɛ wate m'ase a.
So let's apply the rule based on our working. Nipa no you refuse the visa. Visa no you refuse the COS no use no was based on the existing law. Into your best share circumstance. Nipa yi as a lawyer. Me kwafa me kunu aba. Me ba no na ye worry ye. Afi na ya worry na me kwafa na ba. Me ba krom ha 2023. And
Okay.
so emra no. Me company first one no. Me kwase sign e ko second company. Na third company the January ya na minya ye. Ma switch ya ma change employers. Third one ye. Na me won new COS na me de kwafa me kunu aba. Omo se mra na asante omo refuse no. Na lawyer eto asumu ana ya meka say the case worker no wire wrong mante ase. Mra na say obi a no owo old one so no before
Yeah.
11th of March no affect no. Wo de na wo ho na wo ya na say wo transfer
Okay.
doesn't change. Mra no nka say wo transfer a ebesisa dey bi. Nti saa nipa no we can challenge the application on the basis that the case worker applied the rule wrongly.
Wrongly. Okay. Exactly. And yeah, a touch yo lawyer Chasasma. Say a question a bar na matrato na ya combating and tem na afe ye hu na last one na sana makanya all board nation no sa extension of time no say bia o yare bibinti na went to me the time I dey ama say ube gina so 7 days 14 days 28 days na ye gina so say saa mmerɛ na wotumi de yɛ administrative review no na sɛ saa mmerɛ no na wonim mbia sɛ yareɛ anaasɛ biribi no ɔsɛ wotwɛn meka yare a mbia yare ne deɛ mbia na wayare akɔda hɔ nti o 7 days anaasɛ twam na afei na woyɛ a nti ɛhɔ na case worker no sɛ wowɔ evidence sɛ na woda hospital a na ɛkyerɛ sɛ wode ka ho deɛ a case worker no ɔbɛhwɛ sɛ ɛna ɔka sɛ ɔbɛconsider anaasɛ biribi na in this case no saa bere no sɛ ɛba ne sɛ wode kan mbia ɛtrɔ mo sɛ woda hospital nti wontumi nya application no anaasɛ mbia biribi esi anaasɛ like biribi pɔtee nti a very tangible nti a wontumi nsubmit wo review no nti ɔmoma wo mmerɛ kakra na fa yɛ saa adeɛ no a patwɔ saa time no na ɔsɛ wotwerɛ ɛkɔ anaasɛ wode adekode na esi no wobɛtumi atwɛn wo ho san wa na wode evidence na aka ho na wode kɔ mpatwɔ ɛhɔ no menim sɛ wate maseɛ me question a when is the right time a ɔsɛ woyɛ saa extension of time ne sɛ ni say na ato me nti no mentumi submit me review no until sɛ bi a me ho atɔ me anaasɛ biribi patwɔ.
Yo, of course, we yare. The question is, for how long then are we yare? And again, because we are discussing fairness, there's another maxim of equity or principles of equity. I'll say, delay defeats equity. Delay defeats equity. And therefore, if you have to act, you must act in time.
Okay. All right.
Yes, see, I'm out 14 days, my boy.
Yes.
If you want to act, you have to act within 14 days.
That's correct.
Our culture says, we been to media. Tell us why. And maybe, if it is possible or practicable, we will consider. Now, who evidence is now we are?
Yes.
Evidence now what they buy any chance who to Andra. No, who to Monday. And a Friday now what the application no eba. Until why you late? How many days?
4 days.
See, are we saying 4 days is because of sickness or is because of your laziness?
And your laziness, And
So
yes,
then in that case, delay defeats equity.
equity. Okay.
But if it is also catch say if you are bringing it late, you have to bring it, and the caseworker will look at it, and you have to do it as soon as reasonably practicable.
Practicable. Okay.
When did it become reasonably practicable? Was it today, Friday, or Monday when you became well?
It was Monday.
Monday was reasonable, practicable day
Practicable.
after
But
your
we can,
illness. But you didn't, and therefore Friday has made it unreasonably practicable.
Okay.
Unreasonably practicable, so they won't accept it.
They won't accept it. Okay.
Because who told we could na wakai say.
I've been what I say.
Baby.
My application said me submit here.
We don't entertain those people. Son of my culture.
That's correct. And producer for questions ni good board ni so mami na say na dey discussion no I eat into our calling time no but ni nyina is good. It's such powerful education based on this particular topic. I see if the other parent is diseased then death certificate will be required for sole responsibility, right? So I say rhetorical question, you know. Me answer,
then death certificate will be required for sole. No, death certificate will not be required for sole responsibility. Death certificate will be required to show that the child qualifies to join the only surviving parent. It's not just to prove sole responsibility, because sole responsibility is a different thing. So death certificate, you are using it to show part A. Part B is the sole responsibility. And in this case, where there's death, you have to show sole responsibility plus death. But then, sole responsibility will not be a big deal, because automatically, solely responsible. And that Nipani Bisa say, does it mean it's a death certificate or what? Then automatically, what was sole responsibility? The answer is yes. But then we have to show, say, since you have been doing it all the time. If there's no evidence that you've been doing it all the time, then you cannot rely on death alone.
Okay. Yɛate aseɛ wɔ hɔ. Na yɛwɔ question bi wɔ hɔ a producer ɔmo a asɛne ne WhatsApp messages no, yɛnhwɛ Prince Gyemandeɛ no. Say, good morning, lawyer, please. I would like to bring my wife from Ghana. My P60 shows 30,000 for the year. Can I use it to bring my wife?
Yes.
Requirement, yes,
What they need is 29,000.
29.
It's over 30,000 for the year. Are we okay?
Okay. Na kyerɛ sɛ obetumi de ayɛ, but other requirement deɛ wɔmbisa say sika na. So if we can pick yɛn time ne koraa so, if we can pick one call na yɛtumi akɔ de aba awie a, but so far no discussion yɛama yi nyinaa no based on say UK visa refusal is administrative review always necessary. Na yɛtumi ahu where ɛyɛ necessary, where nso ɛnyɛ necessary. Na in a nutshell no mimi nyinaa ɛmɛka sɛ whereby a wonim sɛ you at fault, wo no wo baby a wogyina ne ngyina yie a, there is not necessary sɛ wobɛkɔ akɔpere ho sɛ wokɔyɛ administrative review. But sɛ wonim sɛ adekode no a wo submit yɛ biribiara ɛyɛ na kyerɛ sɛ mfomsoɔ no ɛmfiri wo ɛfiri ɔmo de a, na ɛneɛ you have the necessary right sɛ wobɛtumi akɔyɛ administrative review. Na lawyer Asma, baako bi a mede bɛka yɛnim sɛ administrative review sometimes na yɛsi a delay nti sɛ wonim sɛ bi a nneɛma a ɔmo akeka a ɔmo pa akyerɛ no wo feel sɛ ɔmo yɛ wrong but wo sign your application ni bio ma ɛtɔ asom anaasɛ nka ɛno no mmra ntɛm a ɛno ɛtɔ asom anaasɛ still no if it's necessary then you have to go and do the administrative review.
It depends on, as you said, timing. So imagine say one uvisa no na ebewu endra. Ɛna wode application to mu endra. Ɛna nne yama wo decision say you refuse. So okay, say when you administrative review now your application for fra. So already we overstay.
We overstay, no correct.
So you can't make application. You have to administrative review becomes the only option to protect your status.
Okay. Yo, yɛate aseɛ ne nyinaa yɛ timing no na ebi wɔ hɔ a sɛ yɛka ne sɛ decision no nso ɛkɔ mo hɔ na ɛkɔkyɛ wɔho te sɛ decision ɔmo de ma wo no akɔ wode kɔ ntɛm you made your application on time but ɔmo kyɛ ya ansa na decision no ba ɛno nso no time a decision no baeɛ no ebi koraa na ɛboro ayi mpo na wadeɛ yi mu ewu dadaada nti na ɛwɔ ɔmo hɔ no obi bɛsɛ woyɛ safe nso ɛbaeɛ yɛsi yɛ refuse yɛbaeɛ yɛsi yɛ refuse na yɛatwa almost a year na yɛ refuse no ɛhɔ no na yɛ ana ɛha adwen sɛ wobɛyɛ administrative review na wogyina yie di a ɛneɛ nka ɛneɛ lawyer Asma kaeɛ sɛ sisi a visa na ewu no di a ɛneɛ administrative review no nka ɛyɛ sɛ no na wobɛtoa so woka sɛ wosan akɔyɛ visa foforɔ di a na ngyinasoɔ bɛn ɛna ɔwɔ a wode kɔyɛ saa visa no mbia na bibi wɔ hɔ ɛndeɛ lawyers na enim ne ɔmo betumi ayɛ lawyers ma sɛ mmerɛ ne ɛkɔ na ɛkɔ no nso no etiefo mo fa nkyɛn yɛanhyɛ aseɛ ntɛm mmom na nso no mmerɛ no ɛbɔ 11 no lawyers ne ɔmo hia ɛwɔ office hɔ nti dɛn na wode begya yɛn anaasɛ wobɛ summarize ɛde ama yɛn ansa na yɛasɔre yɛn aso.
Thank you very much, viewers and listeners. Today we looked at when is it necessary to file for administrative review when you have been refused a UK visa. We learned that to be able to challenge a refusal of a visa under administrative review, you have to be sure that the caseworker made a mistake. Either they made the mistake to apply the rule. Example, they thought that your visa, your COS, they thought that your COS is 6131, 6135, or 6136 and refused your dependent. Meanwhile, The COS is for nursing COS, which allows dependents. And so it's a clear error on the part of the caseworker, not understanding the law and applying it correctly. So you can challenge it, and that is necessary. We also understood that there could also be an instance where the person may be applying using COS, of course. The COS application, the COS has not been issued by the employer because the employer is still waiting for the COS. Meanwhile, their visa is about to expire. So they put in the application. They are supposed to provide the COS within 3 months. They didn't, and the application is refused. On that basis, they cannot challenge the decision because they were given time. But if they were not given time and a decision was made and the COS is now ready, then they can challenge the refusal to say that the rules, even though was followed on the basis of COS, the policy guidance was not followed on the basis that the COS was pending decision by the Home Office. And that is why the person made the application without the COS. So these are a few examples. Again, if the caseworker was supposed to come back to confirm certain things from you, evidential flexibility, and they didn't do that, and the application was refused, you can, of course, challenge the refusal on the basis that they failed to exercise evidential flexibility or apply the evidential flexibility rule to give you opportunity to to clarify what they were not sure about. In all this, whether it is necessary or not necessary, you have to decide whether there has been an error on the part of the caseworker or no error. How do you do that? You check the decision letter, you read the reason for the refusal, compare that to your application, and check whether they are right or you are right. If you are right that everything was done correctly, then you can challenge. If you realize that they are correct in what they are saying because you made a mistake on the application form or any of the document provided was not correct, then you cannot go for administrative review because they are right to refuse. These are the things we have covered today. And therefore, when you are refused a visa, before you decide whether to go for admin review or not, check whether it is necessary within the rules or not. Yona,
Charles, you better say, just as you summarize, and I'm say, will be the message about, but I'm saying, Reno call intino,
let's take it quickly.
okay, na member, Emma, na, say, Ubisa, and maybe, member. Good morning, my name is Uncle Charles. But I have a question related to Uncle Ben, proxy marriage explanation now on the bar in a short video last week. You know, Obi be some question be na me person me clarify. Obi wa ha oni hwe, wa hia obi. A on pa ko ne kita indefinite o krom ha. And o person ko ware na. Unya proxy marriage video kito ebi. And I all wonder say, bit me anyway back on a proxy marriage or Ghana, nobody at all. Hana. Bear in mind, say, Unishe, so the visitor to the buy now. Maybe another first Nanka be explanation is like a EU for Nanka omit me, yes, sir. But we do in back on look at indefinite to chroma. Okay. But what's in the question, you know?
I say, proxy marriage video, no, and what's some will be some second part in the man.
Okay. Or see, based on near Uncle Ben video na circulate about proxy marriage. No, see, we no, nipa no, indefinite waha. And na we share obi or no only sure the visit nearby, and I'm say abe wu about came to nishi sisia. Into bisa say omo case say no betumi aye omo akoye proxy marriage no na omo de abetuma bra nipa na only hwe no ewa ha na ono nso kita indefinite ana na onim sɛ ɔno no ɔsɛ onim ɔno nim deɛ no onim sɛ nka yiyifo ɛna etumita ɛyɛ saa but onim say wo a okita indefinite nso no betumi ayesa.
Yo, now nipa no a onni nkrataa no ontumi engina ontumi ntena UK na onye application based on na yere no anase ne kunu no a ɔwɔ nkrataa no. Indefinite ubetumi de afa wɔ yere anase wo kunu. Na mbom sɛ wo kunu na sɛ wɔ yere no onu agasa onni nkrataa a ontumi njoin wo. Because wontumi ntena UK a wonni nkrataa na wonka sɛ me yere anase me kunu agimatum. Na mbom sɛ wo ba de a anase waba no ma de a ubetumi. That's the difference.
So
Nti saa nipa yi a onni nkrataa yi. Sɛ ne yere anase ne kunu no ɔwɔ indefinite no. Ɔwɔ ba a akwala no bɛyɛ ne stepchild. Yes sir.
Sir.
Which be a stepchild no so even though onni nkrataa na akwala no nti
Na ye de ama.
no a ɛwɔ Nationality Immigration Asylum Act section 117D and 117B and Border Act section 55 no near the map nipa no. Yɛbɛka sɛ ebi wonni nkrataa ba akwala no nti yɛbɛconsider wo. Sɛ kɔ kurom na kwayɛ fi hɔ a ebi a saa time na wɔde bɛfi kurom ha no bɛ affect akwala no. Nti yɛbɛconsider wo. Ba sɛ akwala anim di a agye sɛ ɔkɔ no kurom na ɔkɔyɛ application.
Okay. And to conclude hono se akwala wom na obegyina akwala no so na ɔde enya na ye mana ekyire no se okunu no se yo oba na okunu se ne ɔware na se no de sisi a wenya akwala no wenya bi wɔ akwala no ho nti sisi a no mbetumi ayɛ proxy marriage no de aba because ɔwɔ bi a ogyina akwala no so de enya na afei papa no nso aware na na no nso ntumi nye ne saa.
As I say, say, marriage has nothing to do with visa.
Okay.
Me here. Say me ti we me ni nkrata na me hia wo na ye ware a na ye ntumi nkɔ ye kurom a ye betuma me busuafo agina mu amanyen.
Okay.
Na ye bra eno nkira say me de pagye nkrata pajawaja here.
Matthias, yeah.
Until utimu na opesa ware a obetumi aware through proxy customary marriage from your country. Semrano makai. Ntane ya number 1. Na mbom sɛ waware awie no opesa wogina so de gye nkrata. Then we are moving to number 2.
Okay.
Application no still check is to qualify to do it in the UK or not. Application is some na yeka enye aware no. You can do it in the UK without going to your country. But so the nkrata dia then when you say akwala nim ubey na waje nkrata no wa ha say
Abraham ni bibia. Okay, it makes a whole lot of sense. Yo, lawyer Charles Asma, you better say na iti for so meda mo nyina ase na ahwefo meda obi biara ase se munya mre eka ye ho free ye sha ase na up to this time. Me gidi say munya adusua de efree edwumade a ye mu na nyame ya adoma next week same time same place ne be Sunday another beautiful topic and so ababa until then no nyame ya adoma china Saturday your committee and the law, the community and the law honor. And also your very beautiful topic did say be a whole lot of beneficial map do na make a date with us 4 o'clock sharp na 6 o'clock. Join us na also benya uchefa wo. Aha ne di dwumedie ne besi meda obi biara ase. Nyamema adepa ana a very weekend and to na ye ninja. Have a lovely, lovely weekend. Until then, we'll meet again next week, same time, same place. Have a blessed one. Bye bye.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specializing in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.